Mr. Chairman, I wanted to introduce a letter that was sent to the council or by the council from Mr. Meadows to Mr. Thompson, Chairman Thompson, and the other members of the Select Committee on December 13th, and just to ask unanimous consent
Without
to enter
objection.
it into the record. Thank you very much. Mr. Chairman, did Mr. Meadows write you on October the 6th to request the Select Committee identify topics which he might be able to provide useful, non-privileged information?
I'm certain he did, if you're referring to a letter.
Yeah, I'm sure you're right. Did you engage in accommodations process to narrow the scope of the subpoena? Was that a serious back and forth discussion?
Well, we've been back and forth with Mr. Meadows' counsel since September on various issues. At no point did we refuse to engage him.
Did you ever seriously consider, was your subpoena absolute, or were you willing to say, yeah, there are some privileged areas here that perhaps are beyond what we should be inquiring?
The subpoena spoke for itself, Mr. Ranking Member. What we tried to do was to accommodate his counsel on any questions to the extent practicable. That was what we did.
Okay. On November 3rd, didn't Mr. Meadows write again, stating he was, quote, willing to explore with the Select Committee whether outside the confines of the subpoena an accommodation could be reached by which he might be able to answer under agreed-upon appropriate circumstances a limited set of questions that would further a valid legislative purpose within the scope of the Select Committee?
Well, you know, the subpoena required a deposition, and we have, as a committee, sought to depose him pursuant to that. Now, we can negotiate around some other issues, but he has to sit for the deposition.
And can that deposition be limited in any way before you sit down? Isn't that the purpose of the negotiation, to see, okay, there's non-privileged matters that certainly, and as you suggested in your testimony, and he clearly thought there were areas that were non-privileged that were appropriate for the committee to be asking about.
Well, if he felt there were areas that would be outside, then he could put them forth at that proper time, but we felt that he needed to do it at the deposition.
Okay. After additional exchanges of letters, you wrote to Mr. Meadows on November 9th, unilaterally stating that, quote, it appears the accommodation process has reached its natural conclusion, yet Mr. Meadows was still seeking to define the contours of accommodation. Is that correct?
That's correct.
Okay. What legal standard did you use as the basis for your decision to decide, despite ongoing correspondence, that the accommodations process was over?
Well, the legal standard was the fact that every person that has offered testimony to the committee, we've tried to work with them. But it's the committee's standards that we adhere to, not the other individual.
Okay, on November 19th, did Mr. Meadows send you a letter to clearly communicating a list of topics on which he was willing to provide responses to written interrogations?
Well, in all deference to Mr. Meadows' counsel, then, you know, he can say it, but it's left up to us to accept it as a committee.
Mr. Chairman, could I'd like to make sure that we enter into the record all of the committee, all of the chairman's responses to Mr. Meadows' attorney, because in addition to what the ranking member is referring to, the committee has engaged with Mr. Meadows' counsel multiple times, providing with him lists of topics about which we'd like to question him that are clearly non-privileged. And if he has a privilege claim he needs to make, he needs to appear and assert it on the record. But his refusal to appear at the deposition that was scheduled when he requested it be scheduled at the end of multiple exchanges back and forth made his assertion of that privilege on the record impossible. And he has never indicated to us any justification for his refusal to appear to discuss non-privileged materials, and that's because he has no basis for which to refuse to appear to discuss those materials.
Without objection.
Okay, Mr. Chairman, has Mr. Meadows provided you with 1,139 documents, 6,836 total pages, and a privilege log for any documents withheld?
He has provided the committee with a number of documents.
Okay, did Mr. Meadows also provide 2,319 text messages and a metadata from his personal cell, 20 documents from his personal computer, and a privilege log for any withheld text messages?
Well, to the extent that the numbers you quote are correct, those documents are what we have. The question, Mr. Ranking Member, for a lot of us is, now that we're in receipt of those documents, we wanted to talk to Mr. Meadows about them, and that's why we wanted to get him before the committee for deposition, and he's refused to come.
On the subpoena in question, did the committee issue it for law enforcement purposes or legislative purposes or both?
I would say for legislative purpose.
Okay, that's what I assumed. During our hearing on the Jeffrey Clark criminal contempt resolution, you and your colleagues repeatedly said that Clark could not raise executive privilege pursuant to Trump versus Thompson because Clark was not the one in court, but Mr. Meadows is in court, is that correct?
That's correct.
Okay. And well, again, during the same hearing, you and your colleagues repeatedly referred to the need for document production in order to continue your investigation. If that's, and I'm sure that is the case, but then why are we advancing a measure here that's purely punitive? That is, the committee's not pursuing civil enforcement of the subpoena. Why not the civil course? Why the criminal course?
Well, clearly the criminal choice is what the committee made. We see the lawsuit merely as a delaying tactic on the part of Mr. Meadows, and we have given him, as I've said earlier, every opportunity to come to the committee. We negotiated with him, and at the last moment, he said he's not coming, and then he filed suit, which is his choice. We don't have to, as a committee.
Yeah, no, again, I'm just trying to be clear on this because you clearly had a choice to make, and I think when you choose the criminal course, you assure you're not going to get cooperation. When you choose the civil choice, you might. So I'm just trying to understand why not try that first, civil contempt, as opposed to criminal contempt.
It was a decision that the committee made to go the criminal route.
Okay. Thank you very much, Mr. Chairman. Thank you, Mr. Chairman. I yield back.
Thank you. Mr. Torres.